My name is Jessica Clogg. I'm the Executive Director and Senior Counsel at West Coast Environmental Law and a member of the Gitxaała legal team. I'm very pleased to welcome you all today. And just acknowledging that everyone is zooming in from diverse territories across British Columbia, what is today British Columbia, and just inviting you to take a moment wherever you are to feel that connection to the land, to that territory, the ancestors who've come before you in that territory, and acknowledging that I'm here in Musqueam, Squamish, and Tsleil-Waututh territory today. So we're just hoping that our colleagues and leadership from Gitxaała are able to log back in again, and then we'll go to Gitxała's Hereditary Chief Matthew Heel for a prayer to open us up this morning. I think they're just trying to log back in again. Thanks everyone for your patience. I see the numbers creeping up to 500. We're still needing to get up to our 1,000 participants here. So thanks for your patience. Settle in, and we'll go to the village shortly and to Hereditary Chief Gitxaała.
No. Good afternoon, everyone. My name is Gitxaała. We welcome the whole province. Today, for me, it is unexpected to be called upon, but I'm honored and humbled to be here to share with you a victory of First Nations across the country and in the province. We're honored to be the one to be the lead. And as we begin, I'll be saying some prayer, and I remember those that have gone on before us that were with us. In particular, my late brother Cecil, the late elder Larry Bolton, and Ray Nelson. If I miss anyone, it's not intentional, but all our ancestors have been battling this for a long, long time. Our whole history has been a battle since Europeans came. And we're thankful for the legal team that has brought us through. And so we say welcome to each and every one of you. Fanishim gigit, sigedem hanana, lika gigit, kabawaksik. Sim toich, se tranish no, se mora troilik, se sim sagian. En me sim nach no, schabo gede dem omoksik. In lia ke koch, sta getgaatve. En sim git koch. Nach koren. Schudde mak sim git machskim, de ma lebitwalken mkshwa. Mkharamsk. In Sam's Wells, met de Sam's house. I'll call for a moment's silence now. We try to get them some more. You go ahead and get them lachaga. It's good. You have the hike. Screw my election to oil that want me, honey. Because how am I going to go? We're not doing the Ramla Howden. يبشغنون من قاكسدينكم نخشتا والإمخكم كيام يجب ساعة بغشتبني لسألو ديال كده جمنان يقولوا وقم قوت بالتساقيام وانا تخاني يشتبني دقت قويكش تخاني يشتبني دقت هوكش دلخنا نونر هاي شو جيت كن هاي نقوان برم قم قوت قوة قاك شوالم تساقيام نيكواي ساقنوتو لأونا وايس كريست هل موتكم نيرمان وان Amen.
Thank you, Nisawas. We'll now move to Gitxaała Chief Counselor Linda Innes for some opening remarks.
Thank you, Jessica. I want to begin by a quote from our elders. The land is not something we own. It is something we belong to. It carries our ayauch, our adauch, and our gugulkiansk. When we care for the land, we care for the generations yet to come. Simgigat, Siganmananach, Lucky Gabawalsik. Good day, chiefs, matriarchs, relatives, and allies. Today, we gather not just to reflect, but to celebrate a historic moment for Gitxaała and Ehattesaht. The courts have spoken and they have affirmed what we have always known. Our laws, our governance, and our rights are not frozen in the past. They are living, breathing systems that guide us today and into the future. The victory is not just a legal victory, it is spiritual, cultural, and generational. It is a reminder that when we stand firm on who we are, rooted in ayauch, adauch, and gugulkiansk, we cannot be moved. I want to raise my hands to the Simgiget, our elected officials, to our elders, and to every Gitxaała member who carried the work forward, to our legal team who translated our truths into language of the courts, and to our technical experts who showed up to demonstrate the depth of the problem. We thank you. We thank each and every one of you. This was a collective effort, and it shows the strength of unity in achieving this landmark victory. To be clear, Gitxaała has never ceded nor surrendered our territory or our traditional governance. Our governance is rooted in ayauch, adauch, and gugulkiansk. Our laws are oral history and the inheritance of our title and rights from generation to generation. These are not abstract concepts. They are the foundation of who we are and how we live as Gitxaała. Since 1859, when the Goldfield Act was introduced, the free mine entry system, mineral rights in British Columbia granted without consultation. This system allowed anyone to stake claims on Indigenous land without notice, consent, or respect for Indigenous governance. Under the Mineral Tenure Act, this continued. Claims could be staked for $1.75 per hectare with a click of a mouse, ignoring Gitxaała law and our inherent rights. For generations, this regime operated as if our laws did not exist, as if our people did not exist. The BC Supreme Court changed that. It ruled that the Crown has a constitutional duty to consult before granting claims. And now, this landmark ruling with the BC Court of Appeal has gone further. It declared that the mineral tenure regime is inconsistent with UNDRIP and cannot stand as is. The court agreed with Gitxaała. An overhaul was necessary, and reform of the Mineral Tax Act is now underway. The change is long overdue. Even in the 19th century, the Crown ignored its own laws and policies in British Columbia. They did not negotiate treaties. They simply claimed all the land and resources for themselves. For decades, the courts have urged the Crown to deal honorably with Indigenous peoples and to engage in good faith. That is what Gitxaała wants. We want the Crown to honor its obligations. We do not want to have to continue to fight in court. The mineral tenure regime should have been reformed years ago, and that is why the Court of Appeal said it is manifestly inconsistent with UNDRIP. This ruling is not just a legal technicality, it is a call for systematic change. 6 years ago, the legislature unanimously passed DRIPA to implement UNDRIP. That law says the government must take all measures necessary to align BC laws with UNDRIP. All we are saying is simple. If there's a right, there's a remedy. If we disagree about whether the law is inconsistent with UNDRIP, then the courts can order the government to consult with us and to address this issue. The courts have now decided. They have said that a mineral tenure regime without consultation is inconsistent with UNDRIP, so the government has to act. We call on BC to embrace this. They have already committed to reforming the Mineral Tenure Act. The ruling helps inform that reform. This is an opportunity not just for compliance, but for true reconciliation. When the BC court ruling in 2023 came down, the court ruled there was a duty to consult. BC did not appeal. They accepted and started working on a consultation model. I hope that when the Court of Appeal ruled, I hope that when the Court of Appeal ruled on this decision, BC would do the same thing, roll up their sleeves and embrace reconciling laws. Work with us. It is not Gitxaała law that is creating uncertainty. It is the antiquated laws such as the Mineral Tenure Act. The work ahead is at the heart of reconciliation, and we need to work on it together. So what comes next? The victory is a beginning, not an end. We will continue to assert Gitxaała law on Gitxaała lands. We will work to ensure that any future resource development respects our governance, our Ayaw and our Adaw. We will hold the Crown accountable to its obligations under DRIPA and the Declaration on the Rights of Indigenous Peoples. This is about more than minerals. It is about restoring balance, protecting our lands and waters, and ensuring that our children inherit a world where Gitxaała stands strong. So we call on the government to embrace this moment, honor your own laws, DRIPA, and the commitments that you've made. Roll up your sleeves and work with us. Reform the Mineral Act in partnership with Indigenous nations. This is not about creating uncertainty. It is about ending uncertainty caused by outdated laws. True reconciliation is not just words, it is action. Let's do this work together. Thank you.
Thank you so much, Chief Counselor Innes. You've really set out the pathway. And with that, we're going to move into hearing from Lisa Fong, KC, and Ruben Thielman from Ingeris Fong, part of the Gitxaała legal team and the lawyers who argued the case for Gitxaała before the BC Court of Appeal. We'll call them forward, and I understand they have some slides. Thank you again so much, Chief Counselor.
Thank you. Good afternoon, everyone. Thank you so much for joining us. I know it's a terribly busy time of the year, so it's extra special that you're making time to join us to hear about the case, and we're very grateful for that. Ruben and I are going to take you through the key parts of the case, and then the panel that's going to follow us will talk about some of the issues in more detail. Next slide, please, and over to Ruben.
Thanks, Lisa. Right. So just before getting into what the Court of Appeal decided, some background. Um,
Ruben, you're muted.
Sorry, I'm supposed to be. Lisa and I are right next to each other. I'm
That's my
speaking
fault.
through Lisa's computer. I'm sorry. All right. I will start from the beginning. Um, so this is a background before getting into what the Court of Appeal decided. And as Chief Innes alluded to, the Mineral Tenure Act, it's Gold Rush era legislation, and it continues the free entry model established in the 19th century. And under that model, any free miner may apply online to receive mineral claims. As Chief Innes says, it's as low as $1.75 per hectare. And each mineral claim includes significant rights, including ownership of all the minerals in the claim, a right to convert that interest into a long-term interest in the land itself, known as a lease, as well as exploration rights. So free miners can go onto the claims immediately and explore for minerals and extract ore up to specified amounts, all without a permit under the Mines Act. And the regime grants mineral claims automatically, as Chief Innes says, with a click of a mouse online without notice to or consent from or consultation with Indigenous peoples. Now, note on the screen there, after the BC Supreme Court decision, and this year, in the spring, there is now an interim mineral claims consultation framework in place. I won't say much about it, but in our view, it's the bare minimum. There's certainly no free, prior, and informed consent. Now, Gitxaała Nation and Ehattesaht First Nation each sought reviews of grants of mineral claims by the Crown over parts of their territories, which was contrary to their Indigenous laws and made without consultation. And at the court below, Justice Ross of the BC Supreme Court did find that the provincial Crown owed and breached a common law duty to consult arising from Section 35 of the Constitution Act. However, the court was, this is the Supreme Court below, was silent about the interpretive role of UNDRIP, and the court refused to decide if the granting of mineral claims without consultation was inconsistent with UNDRIP. So next slide, please, and over to Lisa.
Okay, thank you. Just before we get into the case, I just want to talk a little bit about UNDRIP's legal role in reconciliation. So UNDRIP is a baseline for reconciling colonialism with Indigenous peoples. One aspect being reconciling existing Canadian laws with UNDRIP laws. So what's needed to do this? In Canada, we have two main types of laws, statutes and the common law. Statutes are created by the legislature and in daily life interpreted by people who carry out work under statutes. The common law is made up of cases decided by judges and tribunal adjudicators who may be interpreting whether statutes have been interpreted properly or applying laws which have been developed over time. So practically, to reconcile Canadian laws with UNDRIP rights, you have to take consideration and in fact, statutes and the common law. So with statutes, people carrying out statutory work can interpret a statute in light of UNDRIP. Same with the common law. The courts are custodians of the common law and they can interpret the common law in light of UNDRIP. But what happens when a statute's language is inconsistent with UNDRIP? You just can't consistently interpret it. There's got to be some kind of mechanism to bring the statutory language into alignment with UNDRIP. And that's where the Declaration Act, DRIPA, BC DRIPA, and the UNDRIPA, the Federal Act, that's where they come in. So both of these acts have language that affirm the immediate application of UNDRIP to laws. So in our view, that's a statutory direction to interpret laws consistently with UNDRIP. This applies to statutes and it also applies to the common law. Both of these acts also have provisions that require government, in consultation and cooperation with Indigenous peoples, to take all measures necessary to ensure laws are consistent with UNDRIP. So this addresses what happens when there's an inconsistent law, the mechanism. Both of these acts also create long-term action plans to address amending statutes, and that happens over long periods of time, over decades. Now, these acts seem to have provided the solution for what's needed to reconcile laws with UNDRIP. But the BC government didn't agree that the Declaration Acts applied UNDRIP to Canadian laws, including BC laws. And they also didn't agree that where a law was inconsistent with UNDRIP, a court could direct BC to consult with Indigenous governments to bring that law into alignment. Next slide, please. And so that brings us to the Court of Appeal issues. Okay, so the issues, there are really two main issues in the case. Do the Canadian and BC Declaration Acts apply UNDRIP to the meaning of Canadian laws, including BC laws? For example, does UNDRIP apply to statutes? Does UNDRIP apply to common law? Does UNDRIP apply to the duty to consult arising under Section 35 of the Constitution Act 1982? And the second question being, when laws cannot be interpreted consistently, can a court declare the inconsistency so that government must consult with First Nations to align the law? Next slide. So now let's get into the case. Okay, so the BC Court of Appeal in this case, they started by providing their legal reason for why UNDRIP affects the meaning of Canadian laws, including BC laws, before they even went to the interpretation of the Declaration Act. The court recognized that Canada had committed to UNDRIP by Canada's unqualified endorsement of UNDRIP at the UN in 2016 and Parliament enacting UNDRIPA, the federal DRIPA, which expressed the Canadian government's commitment to fully adopt and implement UNDRIP. And these commitments had meaning to the law. In February 2024, the First Nations Family Act reference, in that case, the Supreme Court of Canada, so the highest court of our land, held that UNDRIPA, the federal DRIPA, incorporated UNDRIP into the country's positive law. Based on this interpretation of the Supreme Court of Canada, the Court of Appeal in this case took UNDRIPA as signaling that UNDRIP should be applied as a weighty source for the interpretation of Canadian law in accordance with the presumption of conformity. Now, this impacts all Canadian laws, even without considering BC's Declaration Act. Ordinarily, when Canada signs an international convention, the courts will presume that domestic laws are intended to conform to that convention because lawmakers are presumed to respect Canada's international commitments. While UNDRIP is a declaration of the General Assembly and it's not a convention, Canada is still committed to UNDRIP as if it were a convention. The court clarifies that a presumption of conformity is a rule that requires domestic laws be construed consistently with international law and comity wherever possible. The court also clarified that the presumption of conformity is a rule of judicial policy applicable to both statutes and the common law. So therefore, even before the court examined the language of the BC Declaration Act, the court recognizes that UNDRIP is no longer just a non-binding international instrument. It's not just soft law anymore. It is now a weighty source for interpreting Canada's domestic laws. And I'll pass you to Ruben.
Great, thanks. Yeah, next slide. All right, so what did the court say about the BC Declaration Act, or DRIPA? And so first, this is on the question of whether DRIPA applies UNDRIP to the meaning of BC laws. And the answer from the Court of Appeal is yes. And so on the screen, you see that BC enacted Section 8.13 of the Interpretation Act. And this provides that every act and regulation must be construed as being consistent with the declaration, and the declaration is UNDRIP. And the court reads this to mean that there's a rebuttable presumption of consistency, which is akin to the presumption of conformity at common law that Lisa was just going over. And that's rebuttable. So you would rebut the presumption, presumably, where a provision is intended to be inconsistent with UNDRIP. So if you can't construe something as consistent with UNDRIP and it's inconsistent, what happens? Well, we'll talk about that when Lisa gets to Section 3 of DRIPA. But in any case, this also applies to DRIPA itself, because DRIPA is an enactment, so it's statute, and it too must be interpreted consistently with UNDRIP, if at all possible. And all three justices at the Court of Appeal agreed on this point. So just to be clear, it was a majority of 2, so Justice Dixon and Iyer, and dissenting justice was Justice Riley. But he said, in fact, as we read it, something more. he, on this point, referred to an interpretation that supports the greatest amount of consistency with UNDRIP. You can see the quote at the bottom of the screen there. The objective is maximizing consistency of the province's laws with UNDRIP. Next slide, please. So the court then proceeded to interpret certain provisions of DRIPA. They're on the screen and I'll go over them. And that was because of a dispute about the meaning of these sections. So it's 1, 4, 2A, and 2B of DRIPA. And the Attorney General of BC had taken the position that UNDRIP had a minimal interpretive role, and we took the position that UNDRIP had a strong interpretive role that required consistency. So what do these provisions say? So Section 2 of DRIPA is the purpose section. So it says that the purpose of the act is A, to affirm the application of UNDRIP to the laws of BC, so affirming the application of UNDRIP, and B, to contribute to the implementation of UNDRIP, so affirming the application and contributing to the implementation of UNDRIP. Then you also have Section 1.4 of DRIPA, which says that nothing in this act is to be construed as delaying the application of UNDRIP, to the laws of BC. So the court, how did the court deal with this? The court agreed, first of all, with the court below that 2A, so the affirmation of the application of UNDRIP to the laws of BC, it doesn't implement UNDRIP in the sense that it creates substantive rights arising out of UNDRIP. However, the court concluded that 2A affirms that UNDRIP is, in the court's words, to be used by bringing it to bear on British Columbia's laws. 2B is to add to the process of bringing UNDRIP into active effect. And 1.4 says that nothing in DRIPA should be interpreted as delaying the extent to which UNDRIP affects BC laws, and that's either interpretively or as incorporated into statutory or common law. And on the question of whether UNDRIP applies to the meaning of BC's common law, the answer is also yes. And that's first because of Canada's commitments, as Lisa went over, to unreservedly endorse UNDRIP. And second, because DRIPA applies UNDRIP interpretively to all the laws of British Columbia, including the common law. Next slide, please. Thank you. So what conformity means? The court identifies that conformity with UNDRIP may require that a court assess the source, nature, and reach of each article of UNDRIP. And so some articles may articulate, according to the court, binding international rights or obligations or general principles, whereas other articles may articulate instead a minimum standard or an aspiration. And the court does reject the idea that all the articles of UNDRIP are rights that are to be applied uniformly. And I believe Roseanne Kyle and Joelle Walker, part of the panel, will speak more about conformity during the panel discussion. So next slide, please. So then there's the question of whether UNDRIP applies to the duty to consult under Section 35 of the Constitution Act. And the Court of Appeal again answered yes. The court concluded that DRIPA impacts the Crown's duty to consult. So the duty flows from the honor of the Crown, and that also involves the assumption that the Crown intends to fulfill its promises. And that affirmation in 2A, again, that's, that UNDRIP applies to the laws of BC. The court said that that amounts to a binding Crown promise, that the Crown will act as though UNDRIP content applies to BC laws, including the common law. And therefore, while legislative action may be the best route to align UNDRIP can and should inform the interpretation of the common law duty to consult, according to the court. Now, note that the court does not explicitly say that Canada's commitments and resulting presumption of conformity applies to the duty to consult or to Section 35 rights. However, in our view, such an outcome would be consistent with the court's findings about the impacts of Canada's commitments to UNDRIP. And I believe Lisa Glowacki, counsel for Ehattesaht, will speak more about UNDRIP applying to the duty to consult and to Section 35 rights. So with that, Next slide, and I'll turn it back to Lisa.
Thanks, Ruben. Okay, so now we turn to what happens if laws cannot be interpreted consistently. That's where DRIPA Section 3 provides that the Crown must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure that the law is made consistent with UNDRIP. On the question of whether a court can declare that a law of BC is inconsistent with UNDRIP, the Court of Appeal said yes. So the Court of Appeal agreed that inconsistency is the trigger for consultation. The question of inconsistency is fundamentally a legal question, and because of that, it's clearly justiciable. The court endorsed the principle that where there's a right, there's a remedy, meaning here a right to be consulted about an inconsistency in the law and a remedy of the court declaring the inconsistency and then leading to the Crown consultation with an Indigenous government. Next slide, please. So while not at issue in this case, the court also went on to identify possible types of disputes under DRIPA Section 3. Okay, so the first one was our dispute, whether there's an inconsistency between a British Columbia law and UNDRIP, but also possibly whether the type of inconsistency in issue must be addressed by the Crown taking measures, or what measures should be taken, or the adequacy of the consultation in process, or the meaning of the extent of cooperation. And Justice Riley did dissent on justiciability. He decided that any question of inconsistency between UNDRIP and any specific law was not a justiciable matter. And I found his decision a little confusing, but it seems that the impetus for that is that he thought that was a political question and not a legal question. Next slide, please. The appellants also asked for a declaration that the mineral claims regime under the Mineral Tenure Act was inconsistent with UNDRIP Article 32.2 because of the lack of consultation prior to the mineral grants. The court granted that declaration, but it's important to note that it was granted on the basis that there was no consultation at all, which made it inconsistent with Article 32.2, which provides that states shall consult and cooperate in good faith in order to obtain their free and informed consent prior to project approval. It's important to note that the court explicitly identified that by making this decision, it was not making a decision about the precise content of free, prior, informed consent within the legal duty consult. That's for another day, so that continues to be open. Next slide, please. And that brings us to our conclusion. This case is part of a changing landscape in Aboriginal law as UNDRIP becomes accepted as a guide to reconciling Crown laws with Indigenous laws. There are a number of cases in Canada's court systems that are helping to define the role of UNDRIP. This case is one of them, and if the Attorney General seeks leave to appeal and obtains leave to appeal, then this case will also give further guidance through the Supreme Court of Canada. We won't know about leave until the leave period is over, and so that's going to be around January 5th. Another case is R.C. Montour, where Quebec Court of Appeal applied a presumption of conformity with UNDRIP to Section 35 and also refashioned the test in Vanderpee for Aboriginal rights. Quite significant in that case. This case is heading to the Quebec Court of Appeal. And another case for us to keep our eyes on is Quebec First Nation and Canadian Nuclear Laboratories, where the federal court interpreted the impact of free, prior, and informed consent requirement in Article 32.2 to alter the duty to consult. The court decided that a tribunal had to consult to the extent that was informed by UNDRIP, and it sent the matter back down for consultation. But instead, there were appeals, and the appeal was heard by the Federal Court of Appeal, and we're waiting for that decision now. But again, more guidance will come from that case. And as the Supreme Court of Canada has accepted that UNDRIP forms part of Canada's positive laws in that family reference, and 2 justices have accepted that UNDRIP triggers a presumption of conformity in the Gitxaała case, an opportunity for the court to address these issues seems likely in our near future, whether it's our case or whether it's another case that's coming up through the court system. There will be more. Thank you very much. And now we will go to our panel discussion. And sorry, next slide.
Yeah.
Here we go. Yeah, and our panel is Chief Linda Innes, who you've heard already, and myself and Ruben, Lisa Glowacki, who is our co-petitioner, our co-appellant, and Joelle Walker and Roseanne Kyle for the interveners, First Nations Summit, UBCIC, BCAFN, BCCLA, everybody else. Okay, and then Kevin Hill and Jesse Abel, counsel for the intervener Kiona Metals. And I'll pass it over to Jessica, who's going to moderate.
Excellent. Thank you so much, Lisa and Ruben, for taking us through the case. We're going to invite our panelists up onto the screen now for the next portion. And thank you to all of you. Dozens and dozens of people identified questions in advance for the panel. And so we've attempted to group those a little bit by theme. So I'll be introducing the question, going to one or more of the panelists first, and then once we've gone through some of the questions we received in advance, time permitting, we'll turn to the Q&A. Now, I will note that we did receive a number of questions about the relationship between the Gitxaała decision and the recent Cowichan decision from the BC Supreme Court. And I will say at the outset that the brief answer to those questions is that there isn't one. And that while important, the BC Supreme Court decision in Cowichan isn't our focus here today. So we will be focusing on some of the other questions. So just checking now that we've got our panelists all on the screen. I can still see Lisa clearly here, but let's just bring up the gallery. Okay. So we will be, the first thing that we'll be focusing on is the impact of the decision on Section 35 rights, including the duty to consult. And for that one, we're going to go first to Lisa Glowacki, counsel for Ehattesaht Nation. So Lisa, the court finds that the duty to consult is subject to a UN declaration interpretation. What do you see as sort of the possible outcomes from that type of interpretation?
Thanks, Jessica. What are the effects and what are the outcomes? Well, I think the background is important here that my client, Ehattesaht, they brought this case because they have an incredible amount of mineral tenuring in their territory, and that was taking place without any consideration of their priorities for their territory and their rights. And they were very much interested in achieving some kind of collaborative structure with the government, which would be one that gives them some role in decisions about how mining and mineral tenuring occurs. And UNDRIP and the Declaration Act held out some promise of that kind of collaborative a relationship developing. And in the absence of making much progress there, then they're driven to, well, what process do we have? And one of those is the duty to consult. And so their impetus in bringing in the case was to affirm that they can raise not only their Section 35 rights, but the rights that they have recognized under UNDRIP in the consultation process, and including that that right that's in Section 32(1) of UNDRIP, that their priorities for their land get taken into account, and they have a right and a say in how their land gets developed. So, as we know, the court agreed that that UNDRIP informs the duty to consult, and that Ehattesaht and all nations can raise their UNDRIP rights in the consultation process. So in my mind, that has at least two implications for how consultation will proceed in the future. One is procedural and second is substantive. Procedurally, I think that it's true, the Court of Appeal agreed that there's an inconsistency between the mineral tenure regime as it currently exists, which provides for no prior consultation, and the standard of consultation, or the right to consultation in Article 32(2), that being the free, prior, and informed consent. There's an inconsistency there identified by the court. And what that standard ultimately means is yet to be determined. And I think the court encouraged that gets worked out between First Nations and government actors. I do think that standard nonetheless is higher than the lowest standard of consultation that we currently have under Section 35, that being notice. I do think that it is directed at consent. And I do think that, and yes, it's going to be developed in the future. And there are the possibilities of limitations on that requirement to get consent. Those are built into UNDRIP and they're built into our law. So this isn't an all or nothing proposition, but I do think procedurally it will affect the scope and the depth of consultation in the future when decisions are going to be made in relation to Indigenous lands. Substantively, I think that obviously the rights in UNDRIP can be raised. And there is quite a bit of alignment between Section 35 rights as they are stated and the rights outlined in UNDRIP. But on the other hand, there are some rights that are more expressly articulated in UNDRIP, and that may be helpful to help guide consultation in the future. I think that there's a recognition of decision-making and governance rights in UNDRIP that will be very important for consultation in the future. Currently, our consultation framework does not generally give a lot of, it doesn't focus much on impacts to First Nations governance and decision-making. And I think that UNDRIP will help transform that. And it could do so in really positive ways. Ehattesaht, again, came forward because it would like their priorities to be taken into account. It would like a collaborative framework. It is not seeking to end development. It's seeking to restructure it in a way that they have a role and that respects their rights. So I think that the outcome here in the court just sets the baseline for what can be, I think, really positive developments in the future.
Before we move to the next question, was there any additions from other panelists on that one, on that point?
There's an echo. Is that on my end? Okay. Sorry, I have to remember to coordinate. Sorry, I was just gonna add, building on what Lisa Fong said at the introduction of the presentation about how the court used existing jurisprudence on the Federal Declaration Act, and then also the Montour decision. I know there's a question in the chat about Montour and Quebec, that even independently of DRIPA, I think this decision is building on cases that say, and of course, the province, it's a provincial act. The province doesn't conduct foreign affairs. So the province can't bind Canada internationally, but Canada can do that. And the Supreme Court of Canada, in the reference case that the Court of Appeal basically said means by incorporating UNDRIP into the country's positive law, that creates a presumption of conformity, and that does apply to the Constitution, including Section 35. So it's the application of UNDRIP to Section 35. This case is like very clear about it, but it's not the only one, and it's also not limited or even primarily a function of DRIPA. I would say it's a function of UNDRIPA and Canada's commitments.
Thanks, Lisa and Ruben. Moving now, we had a request, I think, from some of our audience, just to remember that we do have a number of non-lawyers in the audience as we kind of move through things. the decision provides some guidance about a key provision of the Interpretation Act, and that was something that Lisa and Ruben mentioned in their remarks. I'd like to go now to Joelle Walker and Roseanne Kyle, just to speak a little bit more about what the case tells us about interpretation of Section 8.13 of the Interpretation Act, and if you can, maybe to speak to some concrete examples of what that might mean. Thanks so much.
Thanks, Jessica. I'm going to outline a little bit about what the court had to say with respect to Section 8.13, and then the second part of your question in terms of what does that look like in real life going forward, Roseanne will address. So the decision starts out kind of looking at the fact that this provision was introduced in 2021, 2 years after DRIPA had been introduced. And it's really important to remember that there's actually two relevant subsections in here, subsection 2 and subsection 3. And what subsection 2 provides is that for certainty, every enactment must be construed as upholding and not abrogating or derogating from the Aboriginal and treaty rights of Indigenous peoples as recognized and affirmed by Section 35. So subsection 2 is squarely in the realm of Section 35. However, subsection 3 states every act and regulation must be construed as being consistent with the declaration. Now, in the court below, there was less of a distinction drawn between subsection 2 and subsection 3. And that was a really important clarification that came out of the Court of Appeals decision. The majority emphasizes that Section 8.1 provides two separate interpretive instructions when it comes to statutory interpretation in BC, and that they must be treated as distinct sections and distinct interpretive rules. So subsection 2 is aimed at ensuring statutory interpretation that upholds the Aboriginal and treaty rights of Indigenous peoples as recognized under Section 35, whereas subsection 3 mandates an approach to statutory interpretation that promotes consistency between the acts and regulations of BC and the declaration by imposing the requirement that provincial acts and regulations be construed to be consistent with the declaration. So in light of this, the court essentially found two errors in the approach that was taken on Section 8.1 in the court below. The first being that the judge below conflated Section 8.1 2 and Section 35 rights and 8.13, and as I mentioned, did not draw that distinction. In the court below, the judge also made the incorrect assumption that Section 8.1 only applies when there is more than one reasonable interpretation that exists, essentially saying that if there are two interpretations, I must take the one that accords with Section 8.1, 2, and 3. The Court of Appeal clarified that Section 8.1 applies to the entire interpretive process, even if there is only one plausible interpretation. So as a result of this, Section 8.13 requires BC laws to be interpreted to conform to binding international rights, obligations, and principles recognized in UNDRIP, as well as to harmonize with broader international standards and rules articulated by UNDRIP wherever possible. Functionally, this creates a rebuttable presumption of consistency between BC statutes and UNDRIP, similar to the common law presumption of conformity with international law. And the court reached this conclusion based on a number of things. First being that must is imperative. So the fact that it says must be construed as being consistent requires that undertaking. In addition, Section 2.1 Section 2.1 of the Interpretation Act qualifies all interpretive rules. So if an enactment shows a contrary intention, UNDRIP consistency may not be possible. This supports in interacting together a rebuttable presumption of consistency that's required unless the statute clearly indicates otherwise. The court also looked at kind of the legislative context and ongoing alignment efforts under UNDRIP to support this, noting that Section 8.1 came after the Declaration Act, so it came 2 years after, so it demonstrates a continuation of those reconciliation efforts at the legislative level. The legislature since then has adopted measures to harmonize provincial statutes with UNDRIP, and the court found that reading Section 8.13 as establishing a rebuttable presumption fits kind of this broader pattern of law reform that was to be kind of ushered in through the enactment of DRIPA. So the court went on to look at the importance of understanding UNDRIP on its own terms and understanding the different articles of UNDRIP that may inform the statutory interpretation analysis under section 8.13, and that those may be different depending on the particular article and right that is engaged. And the court stated that these distinctions matter because achieving consistency may require different levels of alignment depending on the nature of each UNDRIP provision. And earlier in the decision, the court did go into quite a bit of detail around how some of the UNDRIP articles are binding rights and obligations, some are general principles, some are minimal standards, and some are aspirational goals. So as part of the statutory interpretation analysis, the court was clear that the particular article of UNDRIP and its status are also something to take into consideration. So overall, the court concluded that where an UNDRIP article reflects a binding international right, obligation, or principle, BC laws should clearly conform, subject to local conditions. When an article states a minimum standard or aspiration, a broader margin of appreciation exists. General harmony rather than strict conformity may suffice. But overall, the court does say that where there is that inconsistency, there is a role for the court to say so, which was a position, obviously, that was opposed by the province throughout the appeal. So I would say overall, the decision gives us a lot of guidance on how section 8.1 sub 3 is to be applied moving forward, how that statutory interpretation and analytical analysis will kind of play out as different sections of legislation are looked at, or legislation overall, and how that interplays with the articles of UNDRIP. And so I'll pass it off to Roseanne to address the second part of the question about what does this mean in real life.
Thanks, Joelle. Yeah, really clear from the Court of Appeal majority decision. Explicit comments that courts in Canada have to start getting used to interpreting the UN Declaration because of this mandatory requirement in the Interpretation Act. There was comment about it's uncomfortable. Many of us aren't considered to be international law lawyers, but this is the era we're in, and courts need to start wrestling with what the UN Declaration articles mean. So really, really important. And of course, as Joelle went through, section 8.13 is an interpretive rule. Laws must be interpreted consistent with the UN Declaration. But I think it's really important that the Court of Appeal also linked section 8.13 to the commitments of the province under the Declaration Act. That's another key finding, and something that we certainly focused on in our submissions, that if the court is doing a proper analysis and actually weighing in on what articles of a UN declaration come to play here, is this statute capable of an interpretation consistent with that or not? And if the answer is not, then that is the link to the work that needs to happen under Section 3 of the Declaration Act. So really important that these pieces are fitting together, and together with the justiciable findings, really, really important decision. One of the comments made by Justice Dixon that I found very interesting is at paragraph 96, where she says that the manifest purpose of Section 8.13 is to promote consistency between provincial laws and the UN Declaration, to contribute to implementation of the UN Declaration and reconciliation. So yes, it's an interpretive provision, but it's an interpretive provision that has a very, very explicit objective tied to the Declaration Act. So very, very happy, helpful findings. And the judgment is just so chock full of very helpful comments and findings. We're all going to be spending months, I think, finding all of them. But we were asked to think of some examples, like how could this play out in other processes? And one example that came to my mind were specific provisions in the Forest and Range Practices Act. So many of you will know that there are provisions in the Forest and Range Practices Act around forest landscape plans. So it's a fairly new tool in the province for managing forestry in BC. And section 2.23 talks about the explicit statutory obligation of BC to consult and cooperate with Indigenous peoples whose rights could be affected by a forest landscape plan. So that's an example of where a statute is explicitly saying there must be consultation and cooperation. And this was an amendment that was made as part of the, I think, a part of the alignment work between the Declaration Act and the Forest and Range Practices Act. When you consider Article 32 of the UN Declaration that both Lisas referred to in their comments, which talks about the rights of Indigenous people to determine and develop priorities and strategies for development of their lands and resources, and the obligation that's set out in Article 32 for states to consult and cooperate in good faith to obtain their free, prior, and informed consent before approving anything that affects their lands and resources. When you think about that article in the context of the requirement in Section 2.23 of the Forest and Range Practices Act to consult and cooperate, I would say that on forest landscape plans, the province must be seeking FPIC from First Nations before they approve a forest landscape plan. Now, no court has weighed in on that issue. I'm giving my opinion on it, but I do think the case sets some very strong arguments for that type of requirement. And I see that as a very concrete example of where the court's findings about consistency, because how could you possibly construe the requirement to consult and cooperate with Indigenous people being consistent with the UN Declaration if you didn't include an FPIC requirement, given Article 32. That's just one example. I don't think there's a ton of examples, but there are others where the province has explicitly included a consultation and cooperation requirement or mandate. But there are other examples, and I think those ones are really important to look at in considering, how Section 8.13 interpretive rules must be applied. And of course, we know, very importantly, from the decision that even if there was no Section 8.13 in the Interpretation Act, there is this common law requirement for laws to be interpreted consistently with the UN Declaration. And so that brings in all sorts of interesting arguments, including our living tree of a constitution and the way that the Supreme Court of Canada has set out the test for Aboriginal title, or the test for Aboriginal rights, or the test for infringement or justification of infringement. I think this is all fair game now, and as it should be, because I've always felt that because our Constitution is a living tree that needs to evolve, the fact that the governments have committed to the UN Declaration should affect the common law tests around Aboriginal title and Aboriginal rights. So lots more to come on this, really important decision, and I really appreciate the opportunity to participate today. So thank you.
Thank you, Joelle, Roseanne. And that's a perfect segue because we did receive a number of questions about this whole intersection with international law. And I wanted to turn now to Kevin Hill and Jesse Abel just to take us into that a little bit more deeply. You've got the BC Court of Appeal saying that that the UN Declaration is going to be this weighty interpretive tool, but that we need to take into account the actual status of various rights in international law. Can you help us unpack that a little bit and maybe give us some examples of what might be considered sort of binding international law elements that are also reflected in the UN Declaration? So over to you.
Thanks so much, Jessica. And definitely, I'll speak to that a little bit and then turn it over to my colleague Kevin. But yeah, I think as Roseanne you noted, as Ruben and Lisa you noted, the decision is really exciting because for a number of reasons. Starting with because the majority found that UNDRIP has been brought into the law of BC, brought into the law of Canada. It has immediate legal effect, and so statutes in Section 35 and the Charter need to be interpreted consistently with UNDRIP. So I think that's really exciting in the BC context and federally. What was also exciting about the decision is that the majority of the court found that some key UNDRIP rights have independent status in international law. And so they're customary international law norms, or they're contained in ratified conventions or treaties that Canada has ratified and therefore are binding. And so as a result, those norms are adopted into the common law, they're binding, and they also attract the presumption of conformity. And that means that legislation, the Charter, Section 35, all need to be interpreted consistently with those key UNDRIP rights, those key customary international and convention law norms. And I highlight that because that will be the case in every jurisdiction across Canada. So regardless of whether a jurisdiction has passed UNDRIP implementation legislation, that is the case. So even in provinces like Alberta, which don't have an equivalent to BC's Declaration Act, these same rights have international law status, attract the presumption of conformity nevertheless. So I think big implications for BC, but also for other jurisdictions. But as you noted, not the court was careful to say that not all UNDRIP rights have the same status. Not all of the articles in UNDRIP reflect binding international rights. And so what is required for a law to be consistent with UNDRIP is going to vary case by case. And I think that raises the question you asked, which is like, what UNDRIP rights have binding international law status? And how do you prove that to the court? So I can speak a little bit about some of the rights that the court recognized in the decision, starting with the majority recognized the right to self-determination. It's reflected in Article 3 of UNDRIP, and the majority recognized this is a peremptory norm of international law. That's the highest form of customary international law. So it can only be derogated from, it can only be kind of undermined by another peremptory norm. And that norm is also contained in binding international treaties. So the court gave the example of the International Covenant on Civil and Political Rights. It also protects the right to self-determination. So this really had the court in Gitxaała recognized that the right to self-determination has binding status. And two other rights that the majority pointed to. The majority also suggested that Indigenous peoples' rights to land and resources are generally accepted as a matter of international law. That phrasing is a little bit vague, but they certainly recognize that right as having some status in international law. And the right to lands and resources is contained in a number of UNDRIP articles, like Articles 26, 29, 32. And it's also been recognized as customary international law by the International Lawyers Association multiple times. And the right to lands and resources is also contained in treaties like the International Covenant on Civil and Political Rights, again, that Canada has ratified and is binding on Canada. It's in particular, it's in Article 27 of that international treaty. And UN bodies have recognized that it protects Indigenous peoples' rights to enjoy their culture, protection of their way of life, and their territory and resources. So that's another right that has this binding international status. A third right that the majority referred to is Indigenous peoples' right to be consulted in relation to projects that will affect their lands, territories, and resources. The majority said that this right to be consulted is also generally accepted as a matter of international law. And of course, the right to be consulted is protected in UNDRIP. It's in Articles 19 and 32 sub 2. I will flag the majority was careful in the decision to not say to kind of, I think it left open whether the right to free, prior, and informed consent has that same status. Certainly, it recognized that the duty to consult has international law status, but I would say that it's not yet established that the right to free, prior, and informed consent has that status. I think that remains to be determined and is left open. But certainly, international law commentators have noted that the right to be consulted and potentially to be consulted on impactful projects, that right is closely linked to the rights to self-determination, the rights to lands and resources. They're very much intertwined because the right to be consulted and to provide consent is effectively a procedural protection for these more substantive rights of international law. So certainly there's recognition from the International Lawyers Association and from the Inter-American Court jurisprudence that the right to be consulted and potentially consent has some status. But I think the exact status of the right to free, prior, and informed consent will be worked out as we move forward. But some exciting recognitions from the court thus far, even on these existing rights. So from there, maybe I'll turn it over to my colleague Kevin to speak about how you go about proving additional rights.
Thanks, Jesse. So let's break it into the two categories that Jesse was just discussing. Proving binding convention law is relatively straightforward. A right is considered binding convention law when it's expressed in an international convention or treaty, and it's binding on Canada when Canada's ratified it. So the International Convention on Civil and Political Rights is a good example, and what Jesse was just referring to about how the right of self-determination is one of the key rights expressed in that convention. Just a little caveat on that. I mean, one of the things that you'll be looking to is how that binding international convention law, which is usually expressed as law as between states at the international level, is also understood to be binding international law vis-a-vis states and domestic Indigenous peoples. So that might be a gloss on an international piece of convention law, but worth looking into because often that is examined by commentators. So customary international law is quite a bit more difficult to establish and generally requires evidence. There are two different parts to customary international law, two different elements to the test for it. The first is general state practice. So consistent, widespread practice by states, although not necessarily universal. That's an important thing to remember. We got questions in the court or statements from counsel for the province about how, we don't know what happens in Africa or Asia. How can you possibly say this is universal? It doesn't have to be universal. The second is that it needs to be understood to be motivated by a sense of legal obligation. So acceptance as law by states. It has a fancy Latin name, but it needs to be understood and accepted as law by states. So how do you prove those two different parts? There's some guidance about that from the International Law Commission. On state practice, it's evidenced primarily by what states do internationally and what they do domestically. So internationally, you'd be looking at diplomatic acts and correspondence with other states at the diplomatic level, adoption of international resolutions, conduct under treaties, statements in international assemblies, things like that. And then domestically, looking at executive action, legislation, administrative actions, decisions of national courts. But again, you don't need to go through all 200 countries in the world to show this. You're showing widespread practice sufficient to demonstrate that it is representative of a norm. In terms of the second branch of the test, the acceptance as law, it's mainly shown through what states say, what the statements by states, both at the international level and at the domestic level. So you can look at public statements they've made about the norm. That's probably the easiest. Official publications that emanate from the state itself, diplomatic correspondence about the norm, decisions of domestic courts interpreting and applying the norm, any treaty provisions or conduct under treaties that may be relevant, things that they've said about the interpretation and application of a treaty, and what they've said about UN resolutions that are relevant to the treaty. Those will all be useful. So the reality is you'll often be looking at organizations like the ones that Jesse mentioned, the International Lawyers Association, the International Law Commission, expert mechanisms, UN committees, special rapporteurs, because they will have surveyed those that evidence and provided opinions. That's what we did as interveners in Gitxaała, and the evidence was so overwhelming on self-determination that the BC Court of Appeal was willing to accept it, because you don't need expert evidence and I'll get to that in a moment. You don't need expert evidence according to the Supreme Court on customary international law, but it might not always be that overwhelming. And you might have countervailing opinions from scholars or international bodies. So you can lead expert evidence on it, but it's not necessary. However, for something like free, prior, and informed consent, it's probably prudent because it's not completely clear on the face of the either the scholarly commentary or the international bodies considering the existence of that norm. So yeah, I think I'll leave it there.
Excellent, thank you, Jesse and Kevin. In our questions, there were a number that brought up the fact that in the immediate aftermath of the BC Court of Appeal decision, of course, we saw Premier David Eby vowing to amend the Declaration Act, and I think we had questions both about the political and legal significance of this. Let me just first ask if Chief Counsellor Linda Innes, if you wanted to speak to Gitxaała's perspective on this.
Thank you, Jessica. I've been following the media, and I noticed that there's a lot of rhetoric going on changing or reforming the DRIPA Act or repealing the act. My thought around it is that first and foremost, it would undermine our confidence in the government, and if DRIPA is reformed or repealed, it would be a step backwards for Gitxaała and First Nations. I feel like it would be a trip back down memory lane when it comes to the memories of our ancestors across Canada. When First Nations found the ability to organize in Canada and vote, the government changed the laws so our folks did not have that right to vote under Canadian law. And then when it came to our folks organizing to go to the courts to fight for our rights, to fight for the land, to fight for our children, to fight for education, you name it, the government banished our people for decades, for over 50 decades. Our people were not allowed to go to the courts. We were not allowed to hire lawyers to represent us. So, that's what I'm reminded of with Eby's comments on reforming or amending DRIPA, or even other parties talking about repealing DRIPA. It demonstrates the Crown's unwillingness to take responsibility or accountability. And Senator Murray Sinclair's words spoke to the injustices, and it's, his words about our ability to organize and taking away our voices, those words still resonate with me today. It's nothing new. And what I will say is that regardless of what Eby does or what Canada does, Gitxaała, our laws will not change. Section 35 will not change. We will still stand on Gitxaała laws. We haven't gone anywhere, regardless of any legislative changes that have come down since the time of contact. Our people are still here, and we've seen victory after victory in the courts. And we're not going anywhere. We're not going anywhere. You heard Justice Raw's statement. We're all here to stay. We need to figure it out. And I hope that when this comes, when I hope that EB would come to his will come to the table. I hope that he will come to to the table. We have extended an invitation to EB to meet with us. And, you know, when we're looking at changing these laws, to me, it feels like ongoing suppression of what our ancestors have experienced. And it will continue to create that legal uncertainty. As I said, it's not Gitxaała laws that have created this uncertainty for British Columbia, for industry, for the Crown. It is their antiquated laws, it's their lack of consultation and lack of recognition of our rights and who we are as a people. So, I truly hope that we can, there's been a lot of discussion around rights-based commitments, and DRIPA aligns it with UNDRIP, and changing it would be detrimental not only to Canada, to BC, but First Nations. And I hope that, again, I'm calling on the government to do the right thing, to work with us, to be responsive, and to be factual, be honorable, uphold the honor of the Crown. Thank you.
Thanks, Chief Ennis. Lisa, did you want to add a legal perspective?
Yeah. So as many lawyers in this panel recognize, I don't think that his removing, like Premier Eby, removing the Declaration Act is going to affect us in terms of the interpretation of laws having to meet a presumption conformity with UNDRIP, because that's emanating from Canada's commitments in place. But where I do find it damaging, and I have to say I thought it was puzzling, is when we're dealing with Section 3, because removing the mechanism to deal with inconsistency in laws, that takes us back to when there was no mechanism, which is the place of nations then having to fight under Section 35. Those are the Aboriginal rights cases. Those are the title cases. That is Silcotin, Cowichan, all those cases. So to me, when I saw Section 3, Ruben and I were joking. We were like, oh God, we're going to go out of business as being a bunch of litigators, right? What we're going to fight about. We're going to be in negotiation all the time, because that's what Section 3 is. Section 3 is about, let's talk. Let's keep talking so that we can get the laws aligned, right? And if you don't have that, what do you have? Then you're leaving the nations in the place of, let's go litigate. Let's amass huge amount of money, and let's go fight the AG, and let's go do that for years and years and years and years and years, spend all this money. And then what happens afterwards? You sit down and you negotiate your self-government. So we end up having to sit and talk after spending all this money, all these resources. I thought that one of the things that the Declaration Act was meant to do was to take us away from that. That's part of reconciliation, to move us forward. So it was kind of puzzling to me that that was a reaction from Premier Eby. I thought Premier Eby would want this. It creates more certainty. It's way better for business than it is litigation. Litigation is so uncertain for businesses, for nations, for everybody. So I think it's such a mistake to consider this, and would advocate thinking more deeply. I mean, I could understand maybe government thinking, oh, we need a better mechanism than everyone popping up in court under Section 3, but that's a discussion to be had. There can be better mechanisms. It is not easy for any nation to rally the resources and the energy and for lawyers to be able to go and do like the work that we just did on this judicial review and the appeal that everybody did here. That is not easy, and it's not going to be easy. You heard Jesse, you heard Kevin. I'm listening to Kevin, I'm like, oh my God, proving an article is going to be like, what are we going to do, right? Like that is hard work. So isn't it just makes a lot more sense from reconciliation? We get to the table, let's have that discussion. Let's do what Chief Ennis says, roll up your sleeves and let's have those discussions.
Can I just add to that? Sorry, I'm just going to try to add, bearing in mind that the time but we've had some questions for some plain language, because I know there's not a lot of, there's a bunch of people that aren't lawyers in the chat. So the case, and there's plain language I can make it, is a lot about the role of the courts. Because this legislation was passed, Section 3 says the government must, in consultation and cooperation with Indigenous peoples, align its laws. The question for the court was, is there a role for the court in that? And they said yes. And in our view, that was fairly obvious because the court did what courts do. It interpreted a statute. In fact, the Court of Appeal said it's quintessentially justiciable. Justiciable is just this word that means yes, there is a role for the court. So I guess in reacting to Premier Eby's response that this decision puts courts in the driver's seat, and frankly, I just don't see that. Because especially in this case, as Lisa says, it's puzzling because this is about the mineral claim regime under the Mineral Tenure Act, and that is already on the DRIPA action plan. The government has already committed to reforming exactly this act. So it doesn't alter or change any stated legislative priorities anyway. It just confirms what presumably the government already thought, and the court agreed, which is manifestly inconsistent with at least Article 32.2 of UNDRIP. So I don't see a reason at all for that reaction.
Thank you, all of you. It was an amazing panel. We had here today the appellants in this case, legal counsel for Ehattesaht First Nation and Gitxaała Nation, and for our important interveners who were there alongside the appellants the whole way. And as we close today, I really want to reflect back on Chief Counselor Ennis's words and the reminder that the nations brought this case forward as a matter of their inherent jurisdiction, their own laws, and their desire to care well for their people and territory. And that is not going away. You heard the urging, the perspectives of this illustrious legal panel. We got a lot of questions from folks, as an ally, what can I do about this? By all means, we are in a democratic situation. Have a conversation with your MLA, drop them a line, give them a call. If you are moved to defend DRIPA at this time and to emphasize that our shared prosperity, certainty for all of us in terms of the future we want for our children, if you share the view that DRIPA is supportive of those goals and not contrary to them, let your decision makers know. And as you sit around the table in your various holiday celebrations, think about the conversations you might have with those near and dear to you, because these are issues that matter to all of us and to all of our children. So thank you all. We are at time. There will be a recording from the webinar, and we will be back in touch. Let's continue this conversation. And my thank you again, once again, to all of you.
Thank you, everyone. Thank you all.